Good morning. Today we are going to discuss the nature of negligence. Negligence means what? The defendant was having a duty to take care towards the plaintiff and he has broken the duty. The plaintiff has suffered damage, suffered loss. Therefore, he files a case for getting compensation. This is negligence. Today we are going to discuss the nature of negligence. There are two theories for explaining the nature of negligence, telling about whether negligence is a specific mental condition or whether it is a conduct. It is just a conduct or it is connected with some mental aspect. There are two theories. The first theory is subjective theory. The proponents of subjective theory are Austin, Salmond. Winfield is also supporting this theory. What is the subjective theory? This theory says that negligence is connected to a mental element. It is a mental element because man forgets his duty. He forgets his duty. He does not take care. Therefore, it is connected with certain mental aspect. Austin, he has explained this theory in a form like negligence is a faulty mental condition which is penalized by the award of damages. What Austin is telling? Negligence is a faulty mental condition. Faulty mental condition. It is something fault in the mind. The person forgets and all. Therefore, it is a mental condition, a faulty mental condition which is penalized by the award of damages. Austin, Salmond, Winfield, they want to connect the concept of negligence to mentality, to mental condition. Salmond states that negligence is culpable carelessness. What is culpable? Culpable means blameworthy. Culpable carelessness. A person has to take care, but he does not take care. Therefore, he is blameworthy. He should be blamed. He should be penalized. He should be made liable. Therefore, it is a culpable carelessness. A person is not taking care. That is called as negligence. Therefore, Austin, Salmond, Winfield, they connect the concept of negligence with mental aspect, with mental condition. This is a subjective theory telling about the nature of negligence. Now, the other theory is objective theory. The proponent of objective theory is Pollock, Frederick Pollock. What Pollock is telling? Negligence is not a particular state of mind, but it is just a conduct. Conduct means what a person has to do, what a person should not do. It is just a conduct, external aspect, not a mental aspect. Austin, Salmond are telling that negligence is connected with mental aspect, some mental condition, and Pollock is telling that negligence is not connected with mental aspect, it is connected with a particular conduct. It is not connected with mind. In the words of Pollock, Pollock is telling like negligence is contrary of diligence. What is diligence? Diligence means you have to be active. You have to be active in your conduct. You should decide in a proper manner. You have to decide, think. Though the thinking is there, it is not connected with your mental aspect. An ordinary prudent man also thinks. He has to think because he has to do certain things. He has to take certain decision. When an ordinary prudent man decides to do something, it means he is going to plan for doing certain things and not doing certain things. So this is not connected with mental aspect, but it is connected with his conduct, certain external aspect. Negligence is a contrary to diligence. According to Pollock, what is negligence? It is contrary to diligence. Diligence means activeness, and negligence is what? Contrary to diligence, means the person is inactive. He is not acting in a proper manner, and no one is describing diligence as a state of mind. I'll repeat the statement of Pollock. Pollock is telling negligence is contrary of diligence, and no one is describing diligence as a state of mind. Diligence is just a conduct. You have to be active in conduct. You should not forget certain things. So diligence is not connected with state of mind. This is the objective theory. Negligence is what? A breach of a duty to take care. And to take care means what? Certain precautions you have to take. And an ordinary prudent man is going to take certain precautions because he does not want certain harmful things. Whatever action he is taking, for that he will take care that certain harmful things should not happen. He will think about the consequences. He will think about the repercussions. Like for example, you are driving a vehicle at night and without lights. So what is this? It is not connected with some mental aspect. It is connected with what? Your conduct. You are careless. If you are driving your vehicle in night, then you have to put the lights. You have to on the lights. If you are driving a vehicle without a light, it is completely negligence because to carry lights is a precaution. It is a precaution which anybody will take. Like any ordinary prudent person will take this precaution and you are not taking it. It means you are negligent, and this is just a conduct. This is just a conduct. It is not connected with mental aspect. Now these two theories are there, completely extreme. Subjective theory is telling that negligence is mental element, while Pollock is telling, that is the objective theory is telling that negligence is what? Just a conduct. It is nothing to do with mental element. Two extreme theories are there. Now what is the correct view? The correct view is the objective theory, because what happens when the judge has to decide whether the driver is negligent or the doctor is negligent while operating, he gives importance only to the external aspects. He is not considering the internal, that is the intention and all. Because if you go in seeing intention, good faith and what and other things, and anything which is connected with mental aspect, what will happen? Maybe the defendant will not be liable. Therefore, we have to connect negligence only to the conduct. Objective theory is like you are omitting something to do, you are making a breach of your duty, you are careless, that is a breach of a conduct, proper conduct, therefore you should be liable. Ordinary prudent man is going to think about this, he is going to follow certain things, or you can say he is going to take certain precautions. You have to take the precautions, you have not taken, therefore you are liable. What has happened? Because of the development in law, negligence has become an independent, a specific tort in itself. Negligence is a specific tort. Therefore, judges, while deciding whether man is guilty of negligence or not, what they do? They give importance only to the external factors. They don't take into consideration the mental attitude. They only give importance to external standard. Like if a driver is driving a vehicle, whether he was negligent or not, we will not go, the judges don't go in seeing the mental condition. They only see whether he had taken proper care, proper precautions, and whether he has not taken it, then why he has not taken it. An ordinary prudent man would have taken. Only these questions will be asked and the driver may be liable for negligence. Same thing happens with a doctor. If a doctor is been accused of being negligent in operating, then we have to just see that what precaution he should have taken, what he has been taught in medical science, what precautions he should take. Being a professional, he has to take certain precautions. He has not taken these simple precautions, it means he is completely negligent. Maybe the patient has suffered. So we will not go into the mental elements of the doctor. This is tort law. Tort law is giving importance to the act. It is not a criminal law. Criminal law gives importance to the mental element. In criminal law, mens rea is very important. Intention is very important. But while in tort law, the main object is giving compensation to the plaintiff if he has suffered. Therefore, we don't go for seeing the mental element, we only go for the external factors, and that is the conduct. Therefore, negligence objective theory is a proper theory. Got it? Okay. Bye bye. See you in the next video.